Hi, good morning. Today we will see a we will see an interesting judgment on liquidated damages. Liquidated damages, whether it is recoverable in the absence of proof. This is the question before the High Court. The facts of the case are that SAIL entered into a contract, Steel Authority of India. It entered into a contract with some X, let us say X, for supply of TMT gas. In the contract, one of the conditions was that the person must possess, at the time of tender, the condition was the person must possess BIS license. And the TMT bar supplied must have the approval of BIS standard. That are the conditions. X applied for it. At the time of applying for the tender, he had the BIS license. An agreement was entered. He was regularly supplying TMT bars to SAIL. During the course of the supply, his BIS license expired. He did not renew it. SAIL sent on reminders to him to renew the BIS license, but he did not renew it. He was going on supplying the TMT bars. This was also accepted by SAIL. The TMT bars supplied by him was accepted by BIS. Suddenly, because of so much of pressure imposed by SAIL, he stopped supply of TMT bars to SAIL. Then SAIL deducted liquidated damages from the bills payable to him and paid the balance. And there was an arbitration clause in the agreement. Hence, X moved this arbitrator. Arbitrator was appointed. Arbitrator said that in the absence of proof by SAIL, liquidated damages cannot be granted. This is what SAIL said. And the arbitrator said. The second point which the arbitrator decided was, the arbitrator said at the time of applying for the tender, the X had BIS license. Only after that it expired. And he said the supplies are not illegal. It's okay. That's what the arbitrator said. Then SAIL applied it to commercial court, appealed it to a commercial court. In the commercial court said liquidated damages is correct. The liquidated damages claimed by SAIL is correct. But as far as the illegality of the supplies are concerned, it said that the supplies were illegal because BIS license was required for supply of the TMT bars, and it has to have the approval after inspection, approval and seal of the BIS, which it did not have, and hence it said the supplies were illegal. This is what a commercial court said. Then this was appealed to before the High Court. High Court said liquidated damages, it is not leviable in the absence of proof of any loss by SAIL. High Court said the arbitrator gave several opportunities to prove the loss suffered by SAIL. In spite of the several opportunities, SAIL has not produced any proof of loss. Hence, liquidated damages is not leviable. This is what the High Court said. High Court relied on Section 74, which is a very, very interesting section, which I will read it for you. 74 of Contract Act says, compensation for breach of contract where penalty is stipulated for. When a contract has been broken, if a sum is named in the contract as the amount to be paid in case of such breach, or if the contract contains any other stipulation by way of penalty, the party complaining of the breach is entitled, this is very important, kindly note, whether or not actual damage or loss is proved to have been caused thereby, to receive from the party who has broken the contract reasonable compensation not exceeding the amount so named, or as the case may be, the penalty stipulated for. This actually, simply put, Contract Act Section 74 says, whether or not actual damage or loss is proved to have been caused thereby, penalty can be levied, liquidated damages can be levied. But this has been interpreted by Supreme Court. Supreme Court says, in one of the cases, the expression whether or not actual damage or loss is proved to have been caused thereby means that where it is possible to prove actual damage or loss, such proof is not dispensed with. It is only in cases where damage or loss is difficult or impossible to prove that the liquidated amount named in the contract, if a genuine pre-estimate of damage or loss, can be awarded. So Supreme Court says, not in all cases that you can just like that claim damages. In case of actual damage or loss, you must prove it first by way of documents, and then only you can get the amount, liquidated damages. Only in cases where it is not possible for you to prove, then your estimated damages can be given. This is what the Supreme Court says. On the second point, based on that, the High Court said, no, liquidated damages cannot be granted to say. As far as the other contention that supplies are valid, the High Court did not agree, because at the time of applying for the tender, you had license, and subsequently it expired, and then you did not have a license, goes against the basic principle. No reasonable man can think of in that way. That is why High Court said the supplies are illegal. As far as the Supreme Court judgment is concerned, I am not. I beg to differ from the Supreme Court. I beg to differ, but I reserve my comments on that judgment for various reasons. Secondly, in any case, I am not Supreme Court to overrule the judgment of Supreme Court. Thank you very much. Have a great day.